सर आपने 7 साल नौकरी भी करी है, तो मैं एक नौकरी से रिलेटेड क्वेश्चन पूछना चाहूँगा। अभी मार्केट में ना हायरिंग या टैलेंट एक्विजिशन का जो मॉडल है, बहुत दुर्गति हुई है कि 3 महीने का नोटिस पीरियड दो, इमीडिएट ज्वाइनिंग चाहिए, और मतलब कैंडिडेट की इतनी अनसर्टिनिटी बन जाती है कि मैं आज अगर नौकरी छोड़ना चाहता हूँ, मैं 3 महीने बाद कहाँ ज्वाइन करूँगा। तो सर आपने 7 साल नौकरी भी करी है, पर आपने एक एज अ बिजनेस ओनर लोगों को हायर भी करा है, तो सर क्या मेंटालिटी रहती है, मतलब।
नहीं नहीं, बहुत बहुत रेलेवेंट क्वेश्चन है। ठीक है, पहली चीज़, तुम एक चीज़ समझो, इंडिया में राइट टू लाइवलीहुड इज़ अबव एवरीथिंग। ठीक है, तो आपको ना एचआर वाले बड़े अच्छे अच्छे क्लॉज साइन कराते हैं, नोटिस पीरियड, नॉन कम्पीट, नॉन सॉलिसिट, राइट, कि आप कंपीटिंग कंपनी में नहीं जा सकते मेरे बाद, आप 3 महीने नोटिस पीरियड पूरा करोगे। भाई साहब, इनमें से एक भी लॉ कोर्ट में इन्फोर्सेबल ही नहीं है। मेरे को आज तक एक बंदा दिखा दे जो बोल रहा हो कि मेरे को ना मेरी कंपनी ले गई कोर्ट, और कोर्ट ने मेरे अगेंस्ट ऑर्डर दे दिया कि मैंने 3 महीने का नोटिस पीरियड बोला था, मैं तो चला गया अगले दिन। है ही नहीं। ठीक है, वो समझो तो, सच्चाई समझो ना कि क्या हो सकता है। भाई लोग ना एक्सट्रीम पे जाते ही नहीं है। कहीं पे कोर्ट कचहरी की बात आ गई ना, वकील की बात आ गई, सबके हाथ पांव फूल जाते हैं। हाँ हाँ, लिखा तो ऐसा हुआ है, मैंने ही साइन किया था। भाई करा था तो क्या हो गया? अगर तूने साइन कर दिया कंपनी में कि मैं आपका गुलाम हूँ, ठीक है, तो कोर्ट में जाके इन्फोर्स करा लेगा कि तू ये जी ये तो मेरा स्लेव है अब। ठीक है, तो जब कंपनी लिख रही है ना 3 मंथ नोटिस पीरियड, ये भाई तू अगले दिन उठ के चले जा, वो कुछ नहीं उखाड़ सकते।
And again, it's both sides. So, one of the thing to be fair to Grover's comment is that if you are being mistreated in a job and you resign the same moment and you can't, I mean, the situation or the environment is such that you can't even sustain an additional day, then it's all fair. I'm sure the law will also safeguard you.
Hi, Romesh Shivastu here, Editor-in-Chief SightsIn. Welcome to our YouTube channel. Please do subscribe this for the HR news, for HR updates, and conversation with the top-class HRs. Today, we are going to talk about the notice periods. Recently, a video gone viral, and in this video, Ashneer Goa is responding a query on 90 days notice period. Few things are out of the facts, few things may be practically correct. So I thought, let me check the facts. What are the facts around the notice period? So to discuss in detail, today we have a distinguished panel. Let me introduce Mr. Ratan Chuk. He's a HR expert and working as a co-founder at Fund Flow Technologies. And Ms. Suma RV. Suma is working as a partner at KSK Advocates and Attorneys. So, Ratan, if I come to you first, so what is the meaning of notice period? What is the purpose of notice period in terms of both, in terms of resignations and layoffs and furloughs, etc.?
So very simply put, once the separation is triggered, like you said, by the way of resignation by the employee or termination by the employer, there's an agreed period between the employer and employee that the employee would serve after this thing has triggered, and that is called notice period. It is designed to benefit both the parties. Employees get benefited in case of termination. They get period to kind of find a new job in that period. And from the employer's perspective, it is beneficially because there need to be some continuation, hand-holding, and finding of the replacement for the position. And this period allows them to do all of that.
And Shuma, what is your comment on this?
Ramesh, thanks for inviting me to this panel discussion. So coming to the notice period requirements, so Indian laws don't define notice period. It doesn't like specifically say what is notice period, but there are laws which speaks about employer's obligation to give notice period in certain circumstances. So from a contract perspective, notice period is the period between intimation of happening of an event and the effective date of event. So in India, we do come across notice period, all these aspects mostly from termination or resignation perspective. So in that case, it is the period between the issuance of notice of termination of employment and the effective date of employment. Coming to the purpose, Indian courts have looked into various aspects of notice period. One is right to livelihood. So when an employer terminates initiates or issues notice to terminate the employment of an employee, it will definitely affect the livelihood of an employee and means of his subsistence. So the main purpose is to give an employee some time to find a new job, right? In one case, it's very interesting to uh, very interesting case where the court also said this is just period is just not to let the employee find a new job, and it be the period that should be considered no period that actually he took to find the job. So in that case they said since he was engaged in specialized work and things like that, where he couldn't find the job, you have to consider the notice period as a period actually he took to find a job. So this is the purpose. So the mainly it's rooted in the principle of giving someone subsistence. And coming to the employee, when it comes to the resignation, it's obviously to give the employer enable the employer to find an alternative. Doesn't mean finding a replacement. Definitely it's finding an alternative, like it can be anything, assigning the job to the existing employees or anything for that. So this is the basic purpose. And one more thing what we usually see in other purpose, as far as the notice period is concerned, so many times employees do approach labor authorities immediately after receiving the notice period. This period becomes a period for analyzing the legalities and reasonableness of the action of the employer. There are many cases where the employees go to labor authorities immediately after receiving the notice, and then case will make up, the labor authorities call for conciliation and cases are settled also. So these are the main purpose which actually served by the notice period.
Ratan, generally, I see that with most of the companies, the notice period is around 30 days to 45 days, depending upon the positions, and so many things are also there. Very few companies are where still we see a notice period of around 3 months, 90 days, you can say. So, is there any limitation? How the companies decide about the notice period, that this would be the notice period when any person resign?
So obviously there is a bit of a tension between the employer and the employee. So if there is a resignation, the employee would like to be relieved as soon as possible because he's quite excited about getting into the new role. And the employer obviously is worried that they have to find the replacement, and proper handover should happen and things like that. So there's always this tension between what should be the right duration. If you flip it, the tension could be the other way around, where if there is a termination, then the employer would like to reduce his cost immediately, while the employee would need reasonable time to get the job. And there, the law is quite, various countries have various laws to protect that. So I think to answer your question, it largely depends on the role and the seniority of the person. On one extreme, if you, let's say if you're hiring a fresher and training them and they resign, then you don't need more than a day to relieve them. On the other extreme, if you're looking at let's say a CXO level position of a regulated industry, where the handover, if it's not done properly, can result into a lot of issues. Let's say somebody is handling a very senior banking position, and banks have regulators, and if handover is not proper, whether it's an audit detail or the reporting detail get missed out, it has a lot of issues that can come out of it. And there, the notice period has to be reasonable. I would think that from 2 weeks to 3 months is quite a range within which we can play. And as I said, the extreme end could be 3 months. But I also see notice period being used in various ways to hold the person for a longish period, where it's not only handover, but you're trying to get as much work as possible. So let's say if you look at the tech industry, where the engineers would like to, where the engineers would like to move around quickly. I think anything between 30 to 45 days at junior level should be fine. But if it's a project manager or a senior manager or a CTO, then you go from 45 days higher up. So I think that is where you have to really come to a reasonable tenure based on the criticality of the role and the seniority of the role.
I think, Ratan, you must have seen the video which gone viral. In this video, Ashneer is talking about, and he's responding query on 90 days notice period, and almost is saying that you can join your new company immediately after putting the paper. Your previous employer can't do anything. What is your comment on this as a HR leader?
So there are two aspects to this. One is the professional aspect, and second is the legal aspect. I leave the legal aspect for Suma to handle. But from the professional aspect, you look at it this way. Assuming you have not been arm twisted at the time of hiring, you have a contract between you and your employer. And do you really want to respect it, or you just want to drop the ball and go? As a professional, do you want to leave your work overnight and then you don't care of what you're doing, or would you like whatever you've done over a period of time to be handed over, wrapped up properly, and given to the next person, so that the organization continuity should continue? So I think, in all sense, in my tenure, most of the people who are reasonable would like to hand over properly and would not like to overnight leave and go. There could be, I'm talking generally, there are exceptions to the rule. And on the other end, when we are the recipient of the service, would you like the other party who's providing you service to vanish overnight and say, this person has resigned? So I was just thinking about this, and it's an extreme example I'm giving. Maybe, again, legally, Suma can answer that. Let's say if you are going through a surgery and you get operated today, and tomorrow doctor says, I'm resigning and I'm leaving. How would you feel about that? He's also an employee of an hospital. Would you say, you can, 24 hours is good enough for him to hand over the job and go away? So it's more about thinking from a reasonable sense, being respectful of the commitment that you have made, and being respectful about the other party, like we normally do in a day-to-day interaction with people. How do we have mutual trust and respect, and then we, in the sense of reasonableness, handle this situation. I'm sure Suma can answer legally what was said in that video.
Suma, what is your comment as a legal expert on this?
Yeah, I agree with Ratan. But one thing we need to look into here is 3 months notice is not a new concept in India, right? So if you see Industrial Disputes Act, which speaks about retrenchment of workmen, it has a special provision applicable to certain establishments like factories, mines, and plantation, where 3 months notice is required. Along, in if those establishment have 100 or more workmen, or in some cases maybe 300 in some states. So in such scenario, 3 months notice is required to be given by the employer to the workman if workman has completed 1 year of service, and there are certain conditions attached to it. So this act is enacted somewhere in 1947, and this 3 months is accepted across the board. And even courts have held that 3 months is required because when there is a mass layoff, and if
in case of resignation, I'm talking about in case of resignation. What is the point?
So when we are talking about the employer obligation to give 3 months notice period, there should also be a corresponding obligation from the employees, right? So the accepted principle for issuance of notice is that the other party is not putting to like inconvenience or hardship, right? So in that sense, we have to look into, and also we have to see various criteria. The courts have said you have to see the a role of the employee, nature of employment, the location, the job market. For example, if the employee is engaged in ordinary role which doesn't require any sort of skill sets, in that scenario 3 months may look exorbitant. So basically, as Ratan said, it's a reasonableness that need to be looked into. And also though laws are silent on the obligation of the employees, since it is a bilateral thing where the employer and employee agree upon certain things, so there has to be corresponding obligation. And definitely if challenged before the court, definitely courts will look into the reasonableness and what is the obligation of the employer and other things as well. So Yeah, I agree with Ratan that there has to be a test, reasonableness, that there has to be, it should satisfy the test of reasonableness. And one more thing is like coming to like comments where, the perception that where employee can just like, submit the resignation and the next day he can just vanish. So that's not the, correct approach. And legally also, employee is required to give, serve the notice period at least to the reasonable extent, and that's why it can be enforced in the court of law. So if the employee breaches, then definitely employer is entitled to damages. Of course, he cannot compel the employee to serve the entire notice period, because you can't force anybody to like work for you, because it's a restraint of trade. So otherwise, the employee is obligated to give the serve the notice period, and employer can approach the court if there is a breach for damages. But what we are seeing is most of the employees don't want to like approach the court, considering the legal cost or longevity of the disputes and things like that. But definitely employer has every right to approach the court of law for damages for breach of the contract.
So generally what happens if the notice period is for the 90 days? So most of the time this is negotiable. You can serve the notice
Yes.
for the 30 days, and for the 2 months you can pay that amount. So,
Yeah.
but in case somehow if any employee who resigns from the company and he is not serving the notice period, then what the employer can do, because that has been the part of employment contract. He has signed
Right.
also the contract. So that is negotiable. That is absolutely fine. But in case he does not honor the contract, then what the employer can do legally?
So legally this is the same thing. Like there will be breach of contract, and as I told, we can't compel anyone to serve any employer for that matter. But there will be breach of contract, and definitely there will be like claim for damages. And also sometimes it so happens like if the employee has not returned the properties of the company, where are the confidential information, or there is any sort of other like breach. In that case, the like case is strong, and definitely the employer will have like can go for a order of restraint in the court of law, and also like if there are any actual damages, that can also be claimed.
So this comes under the breach of contract.
Yeah, it's specifically under the breach of contracts, because we can't like but these are employment agreements or personal agreements for personal services, so we can't specifically enforce them or compel the employee to like compel to work for the employer for certain time. So that's why like it's like taken as a breach of contract, and damages are awarded.
Ratan, what are the basis of the negotiation? Generally, when somebody puts the paper and you start the negotiation, no, I cannot relieve you before the 45 days, cannot relieve you before the 60 days. Then what the basis are generally when you start the negotiation for the notice period?
So it goes through various phases. The first phase is assuming the employee is a good performer. Then there is some conversation around retention and trying to understand what's the trigger for resignation, things like that. So I think few days just go in that process and sometime longer. And then the immediate concern for the manager is to figure out a replacement and uh, transfer of knowledge and things like that, so that projects or whatever work is being done doesn't get impacted. Uh, I think typically, again, at a junior level, 30 days are sufficient. So you kind of, if you fast track it and put a concentrated effort towards the handover, then that can be done. And what happens is that the employer would like to retain, and they are kind of buying time in that process, and the handover process doesn't get initiated at the right phase, and the employee is getting frustrated because he's sitting there, want to hand over, and the employer is not geared up for that. So you think those kind of discussions happen, and eventually the employee comes up with saying, my leave can be offset against the notice period, and sometime the future employer is ready to buy out the notice period, and therefore they are ready to pay for it. So whole lot of parameters come into play. But as I said, underlying thing is the handover happening properly? Is there a disruption to the extent? Obviously, there is a disruption when person moves out, but is there a disruption which can be minimized? That is the key concern of the manager handling that employee, and that typically takes at least 30 days.
Most of the time, the companies ask for the relieving letter before the joining. So if you are joining a new company, it means you must have also the relieving letter. In very hard cases, if you don't get the relieving letter, if your negotiation is not done properly with the previous company, then okay, you can join also without the relieving letter. How do you see what is the importance of relieving letter is here?
I think relieving letter and full and final settlements, which happen at end of the cycle, should anyway be given. Basically, relieving letter is a matter of fact detail saying what was the last position from when to when the person had joined and things like that. So some people misuse it. I've heard it, but that I don't think is a fair approach towards the employee. The important thing that comes into play is the references. Lot of mid to senior level positions go through the reference check, and there, if you have not handed over things properly, or if you have been very abrupt, or even if you spend the notice period and not cooperated, there's a lot of behavioral issues that come up during the notice period also. Then the employer, the manager, can share his point of view when they get a call around what is their view about the candidate. I think that is a far more important thing. And as I said in my previous comment, the reputation that you want to build as a professional is far more important than the legal aspects associated with it. And again, it's both sides. So, one other thing to be fair to Grover's comment is that if you are being mistreated in a job and you resign the same moment and you can't, the situation or the environment is such that you can't even sustain an additional day, then it's all fair. I'm sure the law will also safeguard you. But barring those kind of extreme situation, I think you as a professional who would be hopefully working over 3 decades, the reputation and the network that you want to nurture and establish rather than getting into these short-term issues.
Ratan, but I see there is no standard practice for the notice period. Means somewhere we keep it 90 days, somewhere we keep it 60 days. We are putting on the appointment letter of the 90 days, but we are also open for the negotiation at the time of relieving. So why this is for all the HR fraternity, why we don't keep it the 30 days? Because 90 days is not, neither acceptable nor possible this notice period. So why don't we come together and reduce this to 30 days? What is your opinion on this? What should be the notice period?
Yes, I think there are 2 aspects to your question. One, I think any mature organization has standardized policy around notice period. So the probation period of first 6 months, the notice is just a day. And then based on every company, most of the companies would have grades, and based on your seniority, it can be 30 days, 60 days, 90 days. And sometimes your promotion letters carry that now that you move to this level, your notice period has been increased from 30 to 60 days. So I would not agree that it is ad hoc and randomly done, at least in established and matured organization. There are standard practices and policies around that. Now, coming to 90 days is unreasonable. As I said earlier, at the senior level and a critical role, like the example I gave, it is quite reasonable to do 90 days. So if you're a CEO of a public sector bank, for example, or even a other bank, don't you expect that that professional to give you 90 days? And I have personally in my tenure at least served 3 90 days notice period with quite happiness and pleasure. That there is certainly no problem in doing that. But of course, when I started my career when I was an engineer, somebody would have asked me for 90 days, it would have troubled.
And Suma, what is standard practice when we talk about the layoffs or retrenchment, and what the law says that what should be the notice period in case of layoff and retrenchment, and what the rights employee have in case they don't get the proper compensation or the notice period for this?
So as I mentioned, law speaks about employer's obligation to give the notice, right? There's no corresponding provisions for resignation. So when it comes to like employer obligation to give the notice for termination, there are like, different laws. We have Industrial Disputes Act, which speaks about workmen, non-managerial, non-supervisory employees. So in that situation, like as I said, it's in some circumstances it's 1 month notice with 15 days per year compensation. In some cases, it is 3 months notice with a government approval. They can retrench the employees, and compensation is the same. So the other law which speaks about is the Shops and Commercial Establishment Act. There again, there is a qualifying service where this obligation is triggered. There it's usually like 1 month notice. Most of the states provide for 1 month notice and also a reasonable cause. So you can't like fire someone for without any reason, right? So these are the like main obligations. When it comes to employees' right, if the employer is not adhering to these requirements, there are two things that we need to look into. One is condition precedent, one is condition subsequent to the termination. Condition precedents are those are like issuing the notice and then paying the compensation. There are condition subsequent saying like in some cases you have to intimate to the labor authorities. So like those are the condition subsequents for the termination. If you're like if the employer breaching the condition precedents, those termination will be termed as illegal and void, right? If the conditions subsequents are breached, then that's like that there will be corrective action for that. So the person like the employer who is wants to terminate the employees, they need to understand what are the condition precedents and what they need to do before like initiating this process, or before like actually terminating the employees or removing them from the roles of the company. So these are the two things. When the employee breaches, definitely like there are different avenues. If he's a workman, he can go to the labor courts or like to the authorities initiating conciliation and other things. In case of workmen, there's one thing that law specifically provide for is reinstatement. In case of like wrongful termination, they can get the reinstatement with back wages and so on and so forth, right? Consequential benefits. Where in case of like non-workmen, like managerial or supervisory employees, it's more of like breach of contract, and civil laws will be invoked. Again, there they will be entitled to damages. In most cases, those people may not be entitled to reinstatement. It's always the compensation that is awarded. So employees do have the rights to like in case of violation, they do have the rights, and the employer should definitely look into the legal aspect before initiating any of these actions. And one more thing I want to tell you is like, how do you communicate to the employees? What is the reason that you are communicating? That is also like matters a lot. If you are invoking like misconduct provisions, and you're attaching the stigma to the termination letter, and then saying, okay, I'm retrenching this and following the Industrial Disputes Act, that's not okay, right? So there are like different aspects that
Absolutely,
need to look
communication
into.
matters.
Yeah,
How you communicate
yeah,
that matters definitely.
right.
Ratan, we tried to cover, I think, both the part of the notice period. Anything else you'd like to share with us?
I think, as I said, that from the employee perspective, I've spoken a lot about. So it's basically how do you want to hand over. But from the employer perspective, if you see a pattern in people wanting to leave early or not cooperating through the notice period, then one needs to reflect and see, what is the engagement level of the employees. What's the morale of the employees. Everybody change job. It's part of the game. So we don't expect employees, especially nowadays, to work with one company for the whole career. But why would they get totally switched off? And why most of them get totally switched off is something to be examined. So I think, as I said, any reasonable human being would like to cooperate and facilitate the process. And if it's not happening frequently, then one needs to examine that. And also, like you said, that it's instead of just making everybody 90 days, you have to bring in a proper reasonableness. Just typically when the markets are hot and the job markets are hot and there's attrition is going up, then very quickly you will say everybody's on 90-day notice period. So those kind of blanket policies would certainly not go well. And again, you're not able to justify and explain them. So if you have a business reason to do things, then everybody understand, and we need to kind of keep that in mind.
Suma, any of your final quick comments?
Yeah, so the employment scenario is changing in India and in any other jurisdiction. So we see a lot of now gigification, and then we have co-employment arrangements, and like employees working on part-time basis, and many other arrangements where like multiple employers will be there. So what we are talking about notice period, whatever recognized under laws in India. So these are not sufficient. So it has to evolve, and the government is also making a lot of changes. But yeah, so they need to understand the current employment scenario and work towards it. And also like definitely when these issues crop up, so there are like many aspects that need to be looked into, not just my right, your right, and your obligation and my obligation, right? So yeah, definitely there'll be a lot of tests that will be applied when these questions are raised before the courts, and definitely like courts will also look into various aspects. So hope like government also like consider this, and gives a speaks about corresponding obligations of the employees too.
Thank you so much, Ratan and Suma, for joining the conversation and sharing your wonderful thoughts on the notice period. Thank you so much.
Thank you,
Thank
Ramesh,
you.
for having us. Thank you.